Datuk, I'm sorry I had to interrupt you. I just wanted to make sure that
no problem at all.
the timely
Don't worry. This is normal. We were just making small talk. So this is the main occasion.
We are now live, sir. Participants are coming in. We'll wait for a couple of minutes before we start. Thank you. Yes, sir, we've reached a reasonable number of participants. Any more than 100 would be directed to our Facebook pages where they can see the webinar live. A very good morning, good afternoon, and good evening to one and all present here. I welcome all the attendees and the esteemed panelists of this session. Firstly, I would like to introduce you to the Southern Indian Chamber of Commerce and Industries ADR Center, which is placed out of Chennai, Tamil Nadu, India. It has a secretariat infrastructure opposite to the Madras High Court, here again at Chennai. It has been effectively practicing and providing its services in the field of ADR, both physically and online from April 2019. Now, the center has taken on a new venture to establish this SICKI online ADR webinar series. And on this series, in the first ever panel we are introducing an esteemed speaker with our pleasure. Before which, I would like to call upon Mr. A.R.M. Arun, the President of Southern Indian Chamber of Commerce and Industry. He is also the Honorary Council of the Czech Republic. He is also the Chairman of Valingara. Sir, over to you.
Thank you very much, Mr. Suvendra. I hope I'm pronouncing your name correctly. Datuk Professor Sundar Raju, the founder, President of the Asian Institute of Alternate Dispute Resolution, AIADR, and Chartered Arbitrator. Datuk, I must say that it was very nice to exchange a few pleasantries with you before we started, and very good to know about your Tamil Nadu roots, of course, and certainly look forward to being in touch in the course of time. Mr. Inba Vijayan, Chairman of our Arbitration Committee, and who very effectively is in charge of our SICKI ADRC. I must very much appreciate his efforts. He's been in charge of the ADRC ever since we started not too long ago. We are certainly very keen to be able to grow upon the good work that has been established so far. Yes, it has been a down trend for the COVID duration, but we are certainly hoping to cover a lot of lost ground in the coming months. So looking forward to the efforts of Mr. Inba Vijayan and his committee. Participants from across India and Asia who have so kindly joined us today. Ladies and gentlemen, on behalf of SICKI, I take great pleasure in extending a warm welcome to each one of you to today's, what I would also consider a very important event. A very good afternoon, a very good evening, a very good morning to you, wherever you might be. And I'm hoping that you would be able to find this session very useful. I would like to start off by sharing a few words with you about the Southern India Chamber of Commerce and Industry, SICKI. For those of you who are not aware, SICKI has completed 110 years of service to industry, government, and society. SICKI was founded in the year 1909 under the inspiration of Mahatma Gandhi. In the process, SICKI has inherited a rich tradition, while at the same time, we have remained youthful, dynamic, and embracing change. We are the leading regional chamber in this part of the country. We possess a national outlook and have very good relationships with both the central as well as our state government. We have been conceptualizing and conducting several events, and in the process been very closely working with the government of Tamil Nadu in particular. I would like to talk about two events that we've been working with the government. One is Yadu Mure, which I'm sure will be of use to quite a lot of you, and perhaps a good number of you have already participated in this. We conducted this event along with the Guidance Tamil Nadu, that is part of Government of Tamil Nadu. It was held last October. The objective of this seminar conclave, which ran over 3 days, was basically to reach out to the global Tamil diaspora and bring them to a common platform where we exchange not just culture, but also literature, making friends, and importantly, also looking for business opportunities that might benefit everyone participating. We are going to be conducting this event on an annual basis, so we look forward to you getting to know about it and joining us in the course of time. Another event that we've been doing along with the government of India in this case is that of the Food Conclave. And the idea here is we want to be able to focus on food processing and nutrition, especially during the post-COVID time when there is a lot of requirements in terms of health and cleanliness and so on. And certainly for those of you who are outside, this will be a good way to be able to get your countries to participate in whatever way that you can. In addition to these two, we have been conducting several other events as a chamber. Quite a lot of it is already present on our website. We'll be glad to also share with you if you would like your email IDs to be given to us, and we can add you to our mailing list. With those few words of Sikhi, I would now like to share a few words about arbitration. It is an acceptable fact that arbitration is considered to be an alternative to the adversarial system of court litigation. And this is on account of it being a convenient, progressive, and cost-efficient method of resolving disputes. However, in India, it is the absence of the aforesaid that has sidelined arbitration as an option for parties intending to resolve domestic and international disputes. Parties start off arbitration with an optimistic dream of having their disputes settled in a speedy and cost-effective way. Conversely, by the time arbitration ends and the award is enforced, the parties are in a dilemma as to whether their decision to opt for arbitration was appropriate in the first place. Due to the lack of proper infrastructure, timely arbitration proceedings don't happen, and even if one is fortunate enough, the Arbitration Act provides ample scope for parties to approach courts to intervene in the proceedings on one account or the other. Further, per hearing fees charged by most of the arbitrators at times, it is so pricey that parties just can't afford them. The Arbitration and Conciliation Act 2015 and 2019 has made an attempt to come to the rescue in this regard by fixing fees and timelines for arbitration. But the thorn in the flower is that courts are again to intervene to investigate as to who is to be blamed for a delay in the meeting, any timeline for that matter. Further, the high courts have been provided the power to make rules for fees and the manner of payment, which again would lead to lack of uniformity, as each high court of different states across India would have their own rules that they go by. So what can be the solutions to increase ADR? The panacea to the diminishing future of arbitration in India is to promote institutional arbitration in India. To start with, it is universally acknowledged that the quality of arbitration proceedings depends to a large extent on the quality and skill of the arbitrators chosen. And the courts may not have the expertise in appointment of such arbitrators. While having an arbitral institution making an appointment would be more beneficial, as then they would be specifically organized to perform the function of selecting arbitrators because of their day-to-day involvement in arbitration, as well as their access to a pool of highly qualified arbitrators. Secondly, to tackle the time problem, institutional arbitration should be promoted, where arbitration is carried out on a day-to-day basis, say for instance, from 10 in the morning till 4 in the evening, so that there are no backlog of cases or delays in concluding the proceedings. Fees issue would also be taken care of by institutional arbitration, as such institutions have a fixed fee schedule, which will then negate space for ambiguity. Thirdly, so far as finality of decisions given under institutional arbitrations is concerned, steps can be taken to make the order passed by the arbitrator under institutional arbitration open to appeal or review only by the committee of the institution, so as to negate parties taking the court route. Further, the decision of the above-mentioned committee can be made final and binding upon the parties, and also the parties. Besides, court intervention in arbitration proceeding could be allowed only when arbitration agreements specifically provide for it. Finally, to make institutional arbitration an attractive hub for foreign parties and investors, certain things are to be kept in mind. For instance, a forum is attractive as a seat only if it has a judiciary that is supportive of arbitration. In this regard, the courts in India presently have a pro-enforcement approach. Likewise, the pool of resources that is readily available to assist the arbitral proceedings is another important determining factor in choosing a seat of arbitration. Thus, resources and infrastructure are other minute aspects that demand major attention. Further, the institutions conducting arbitration in India should have enriching bilateral relationships with numerous other national and international arbitration institutions and to ensure constant update of the rules governing institutional arbitrations so as to cater to the specific needs of the respective industries. One needs to keep in mind that any new system or mechanism should be given sufficient time to adopt and accommodate so as to ascertain its success or output. Thus, institutional arbitrators should be given a green flag with patient expectations about its results rather than taking any hasty decisions, because one thing is trustworthy, that if countries like Singapore and Hong Kong can become arbitration hubs on the strength of institutional arbitrations, so can we in India. More specifically, the SICI ADRC is taking that task upon ourselves as a long-term objective. We are also in the process of setting up a SICI chapter at Sri City in Andhra Pradesh and look forward to expanding our arbitration operations there as well. SICI would be doing its best to continue our focus on arbitration through events such as these, knowledge reports, and other key interactions as well. We certainly look forward to your feedback and importantly, your support and patronage as we move forward. In conclusion, I would like to take this opportunity to sincerely appreciate each of your presence with us today. As I said earlier, we are sure that you would find these proceedings useful and certainly look forward to your feedback. Thank you very much and wishing you safe times ahead.
Thank you.
Thank you so much for the amazing introductory remarks, sir. Now I hand it over to Mr. V. Inbovijayan, Chairman, SICI Arbitration Committee, for introduction of the esteemed panelist.
Good afternoon, good evening, and good morning. First of all, the Arbitration Committee is so indebted to our President, Mr. A.R.M. Arun, to give this opportunity to commence this webinar series on arbitration. More interestingly, the words from our President regarding development of institutional arbitration would be seriously taken into consideration, and SICI ADRC would obviously facilitate this expected institutional arbitration, which is the need of the hour. Thank you, sir. Thanks for giving this opportunity and giving us the basic tool what we had to generate. I'm here to give an introduction about my professor, I can say, Datuk Professor Sundar Raju. Obviously, he is a mentor to many arbitration practitioners globally. As an introduction, he is presently the president of the Asian Institute of Alternate Dispute Resolution, a chartered arbitrator, the founder of Society of Construction Law Malaysia. Many things we had to add on with our professor's credentials. Most active one which he took was, he was the first non-European global president of Chartered Institute of Arbitrators some 4-5 years back. And now he's here to deliver us about what is the component of arbitration when it comes to Indian perspective. One more thing to add, he is working on a book for arbitration in India, which is likely to be published by Thomson Reuters. And best wishes, Datuk, for this wonderful task what you are going to start. And we from SICI are grateful and thankful for you to spend your valuable time going to share about the expected arbitration scenario in India. Welcome, sir. Now I hand it over to you. You can share with us about this arbitration landscape.
Thank you. Greetings, everyone. Greetings from Kuala Lumpur. Uh, 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 I'm very thankful to Mr. Arun, President of the Southern India Chamber of Commerce and Industry. Mr. Imba is an old friend of mine. For many years, we've been together, working on common projects and also in communication with each other. Mr. Suvedan, who is actually a very active young man who's been doing fantastic work in the foundation of COVIS Foundation. So, ladies and gentlemen, I have been asked to actually talk about uh, how relevant arbitration is in India. This really comes out because, so strangely, India has a lot of arbitrations, and most of it is ad hoc. Very little is heard about it, except in proceedings in the courts, and we don't see the numbers. We don't know the numbers. There's very little publication of it. So I'm going to actually try to do a simple set out of why it would be very useful to have arbitration in India. And I think one of the great movements that is going on, which is a movement which Mr. President Arun has actually alluded to, is this movement in India towards institutional arbitration away from ad hoc arbitration. So this entails considerable effort. I suppose, India is unlike China. China starts with this idea there's only institutional arbitration. There is no ad hoc arbitration, whereas India started with the notion there is ad hoc arbitration. We are free to choose. And there were very few institutions because such a large country, and there was very little support or organizational arrangement in trying to build up. And I think a lot of the building up of institutional arbitration was rather ad hoc in nature. So starting off, let's start off with what is arbitration. I think for those who are new to this, it's just a mode of dispute resolution, particularly for commercial disputes. But it can go for any kinds of disputes. You are now having disputes relating to maritime, you're having disputes relating to commercial, you're having disputes between investment and investors and states. You have IP disputes. There's even a mode called domain name, which is all, there are a lot of specialty regimes. In fact, even in sports, there's what's called sports arbitration with the Court of Arbitration Sports in Geneva. So arbitration is actually a well-known method of dispute resolution for all kinds of disputes, both internationally and domestically. I won't say it's a fairer process than litigation. It is a fair process, as litigation is also a fair process, because it actually has a structure. Parties must be heard. The panel and the judges are all neutral, and the parties, I think most importantly, are put on an equal footing. They must be treated with equality. So I think moving on, in India itself, I think what has been happening is that you have moved from the old Raj arrangement to a lot of activity. In fact, I think India is going to be one of the great economic powers of the world. In fact, we are talking about being number 3, perhaps in a few decades' time. So if you are number 3 in the world, that means you are going to be a great trading nation. Even now, I think, one of the great resources of India is manpower, and also a lot of ability to create value in terms of industrial output. And there's been a significant trading with the outside world. And that has created a lot of transactions. Now, transactions out of, let's say, 20,000 transactions, there could be one dispute. That one dispute is where the problem lies if you are doing business. So when you actually do business, and if you are actually involved in commercial activity, you you are quite concerned if you get actually bogged down by disputes, and you will try to resolve the disputes, and there will be actually a reluctance, particularly to go to the courts, because sometimes the court system is a tiered system. Once you start, you will go through the process until the Supreme Court. I think that applies to everybody because there is a tiered appeal system. But I think, one of the things that has happened, India was one of very early countries that did the Arbitration and Conciliation Act 1996. In fact, I think Malaysia only did it in 2005. And India also signed the New York Convention quite early compared to many other nations. So I think it is a model law country. It is actually part of the New York Convention arrangement. It also has the Geneva Conference. India is not a member of the ITSIC Convention, but that is fine because that has to do with investments and the state. And I think 96, there's been a flurry of activity. I think the President Arun just explained to us about this emphasis on institutional arbitration, this emphasis on trying to curb delay. And what has happened is that there has been 3 amendments. One is the 2015 amendment. There has been another amendment to the Arbitration Act in 2019. And recently, there is another amendment now going through the lower houses, where Lok Sabha has actually passed it. 2020, it should be enacted as law in 2021. So I think this is all, as we say, moving towards making India an arbitration center, hub, and more importantly, making arbitration relevant when you are actually doing trade activities, trying to resolve disputes in India. So let's then move on to some of the features of arbitration. Very simple. I think I'll go through this very quickly. The arbitrators are supposed to be neutral and independent, and that again, talks about the quality and the characteristics that you require of the people who are going to adjudicate. The process is meant to be flexible. People can decide they can have a hearing, they don't want to have a hearing, they can decide they can have 3 people or they can have 1. They can decide that they want to actually truncate the procedure. Everything can be agreed upon because it's based on party autonomy. Parties can agree to the procedure and the process. And I think if I understand, like I think 2 days ago, Malawi became a member of the New York Convention. And with Malawi becoming a member of the New York Convention, there is now 167 states who are members of the New York Convention. What is the New York Convention? In fact, we should talk about, I was telling people, we should talk about who are the states who are not members of the New York Convention. That may be easier to identify than to identify the 167. So because I think the exception is like it really stands out if you're not if your country is not a member of the New York Convention. But what does New York Convention mean? New York Convention means reciprocity in enforcing or universal enforcement of arbitral awards that are carried out in various jurisdictions. There could be some arrangement on some limitations or whatever they want to put in, but generally, foreign arbitral awards are enforceable in, let's say, in India. And Indian arbitration awards are enforceable in countries who have acceded to the New York Convention. Of course, there is a requirement of reciprocity in the New York Convention that India has actually agreed to. So I think that nevertheless, there is universal enforcement. Generally, arbitration hearings, the procedures, the decision are confidential, except where it's required by law to be disclosed, and this has been actually been legislated recently in India in 2015, 2019. In fact, they make it very, very clear. They also have come up with this idea of redacted awards going to be done by the Arbitration Council of India. It respects party autonomy, and more importantly, as President Arun spoke about just now, you could actually choose the institutions, their rules, and you can have your hearings and you can choose your venues. So hence, I think there will be a proliferation of centers in India trying to create an institutional base for arbitration. I think, summarizing, it is enforceable both domestically and internationally, the award. Then more importantly, there is confidentiality, procedural flexibility, choice of arbitrators. You can choose arbitrators, not necessarily lawyers. If it's a maritime arbitration, you want to choose somebody who has business and commercial, a commercial person, well-versed in the trade. So, and then this is one of the other things that is important in arbitration, is because the process is supposed to be final, in the sense that it ends there. And there's very limited provisions for the courts to interfere, to examine it. I will discuss this in greater detail later as we move on. So, okay, let's quickly do this. Litigation, arbitration. Litigation does not, you can't choose. If somebody decides to file a suit against you, you're just stuck with it. It is lengthy simply because of the tiered system of appeals. And a judge is a lawyer. It's very rarely you get dual qualified persons who sit as judges, but normally the qualification of a judge is you must be a lawyer who's very experienced in practice. Whereas in arbitration, you need to have the both parties agree to an arbitration agreement. So that is very important. There's consensus that we want to arbitrate the matter, and there must be some form of agreement or a submission to arbitrate. It is relatively fast or expeditious simply because I think in the old days, arbitrations can go for a long time, become very expensive, and they take many years to finish. But now, even in India, we have come up with these domestic arbitration rules that say you must finish in 12 months. Parties can give you an extension of 6 months. That means together you have 18 months. If you don't finish it, then you must go to the court and get permission. And the court could remove you, could actually put conditions if it gives an extension. So that actually makes the procedure time bound. People become very conscious that it must be done within a certain time. And then, as I mentioned, there is you can choose very experienced people. In fact, in construction industry, my background, I'm an architect before I became a lawyer. So basically, many of the things that I've done have been construction based. But the similarities, both are formal arrangements. They are rights based. They require a third party, which is called an arbitrator or arbitral third parties. And the outcome is a rights-based outcome. It is apportioning fault. There must be a winner or loser, or sometimes they're both losers, but we don't know. Very rarely, that will happen. But there must be a winner and loser, because a dispute has to be resolved by way of looking at the facts applied to the law, and then that gives you a result, which is formal in nature, rights-based. So again, I think Mastil, passed away some time ago, but he still explained that, he talks about two things. He says that arbitration gives you that flexibility on one side, but because of its finality, it is actually strong and it is enforceable. And there is a judicial framework generally around the world, even in India now, which actually supports and enforces decisions and awards that are made by arbitrators. And it gives the flexibility to choose the procedures to fit the nature of the dispute and also the business context. Okay, I'm just going to explain some of the advantages. We can talk about, we're going to go through one of it, language. You may think language is not important, but we will come to why language is important, the expertise of the arbitral tribunal, and then the thing about arbitral institutions, particularly in India, where you have such a large country, you have the courts all over the place. At the present moment, the courts have the power to enforce to appoint the arbitrators. They are designated as appointing authorities under the Act, but eventually, like in many other countries, they select arbitral institutions, they delegate the power to appoint arbitrators to those institutions so that those institutions, arbitral institutions, are able to administer the arbitration and oversee the arbitration within the ambit of confidentiality. The neutrality of arbitral panels. One thing that is very, very interesting is the choice of representatives, because sometimes arbitration is cross border. So people may want to have their own lawyers, their own representatives to present them in the arbitration, which is before, let's say, an impartial tribunal. Venue can be anywhere. It could be in India, but if let's say even domestic, they may decide not to have a lawyer. They may have an engineer who presents that engineering dispute to the arbitral panel. And then next one is finality, universal enforceability through the New York Convention. Control over the procedure. Control over the procedure is basically just like the courts. Courts have rules and they control the procedure by the rules. Arbitration also has arbitration rules. We have a corpus of procedure that has come out and recognized that it is based on two things. One is that parties must be given a right to be heard, and they must be treated with equality. So with that, you have control of the procedure, where in that parties can structure the procedure as before they actually go into dispute. And then one of the things that a lot of foreign parties, I'm quite sure that I see Indians going to Africa and China and all over the world, trading, doing projects. At the same time, you have a lot of foreign companies coming to India to do their projects or to actually participate in the commercial activity. But when there is a dispute, neither of them want to go to the courts of that particular locality because they feel there is a home advantage, home jurisdiction advantage. The home jurisdiction advantage is that this perception that the courts of that particular country will favor the party. It is actually not founded, but this is just a perception. Perception sometimes drives a lot of things. So, and that is why the arbitration becomes very important, particularly India. When people talk about Indian courts, they say it's going to be lengthy, it's good. I don't want to go to an Indian court. But at the same time, you don't want to go to a Chinese court. You don't want to come to a Malaysian court because actually distances are long. You just, and then you have to hire, let's say, an Indian lawyer or a Chinese lawyer or a Malaysian lawyer. You say, why should I do that? And then I cannot enforce it. Because there's no reciprocity in enforcing judgment. So this actually translates into the advantages of arbitration. Language, I'm coming back to language. We underestimate language, especially in India. Of course, English is one of the official languages. Everybody speaks English. And I think most of the world, English is an important commercial language. But if you go to certain parts of the world, you may get such things like, for example, Spanish. If you go to South America, if you go to maybe France, you will get French. If you go to China, you're going to get Chinese. If you go to Japan, it's going to be Japanese. So language is an issue. You know, when you have commercial contracts that are cross-border, what language, when you have a dispute, how are you going to deal with that? So you need some flexibility. So arbitration does have that flexibility. There are some logistical arrangements that can be decided. And usually parties will have to decide the language to be used. And I can tell you, if you go to a court, the language, let's say in India, will be English. If you go to Chinese court, it will be in Chinese. They will not take the effort to translate for you. You have to sit in the court and maybe have somebody whispering to you what the language is, or you may have to. But in arbitration, I have said in Chinese arbitrations where the language of the arbitration is Chinese, but we had simultaneous translation and important documents are all translated. So in fact, I think I was chosen perhaps to be the arbitrator because I could not speak Mandarin, and therefore the parties also couldn't speak Mandarin. The other party could speak Mandarin, so there is no advantage. So we had to actually ensure that the documents are all translated, and the arguments, when we do deliberate, there's a translator, and we actually, even when the award is written in Chinese, we have translations of the most important part, and so that it does away with this language disadvantage. Again, the New York Convention has ways of handling it, how a foreign arbitral award, which is in a different language, how it's going to be actually certified into the language of the jurisdiction when it's going to be done. Expertise, again, you can select your arbitrators. That's the first important. You normally, I think this is very important. You should select the arbitrators which have the relevant technical experience, or if the dispute is critical with technical component, sometimes you will structure the arbitral tribunal in such a way that you may have different expertise. For example, you may have a complex power plant dispute where you may decide that both party appointed arbitrators could be technical people, could be an engineer, could be a person who deals with process, or a forensic person who can then, and the two people can then appoint, let's say, a chair who is actually a lawyer. So instead of having 3 lawyers, of course, we have expert evidence coming in and all these things, quite common of that. But the expertise can be developed in the arbitral tribunal by the choice of the arbitrators. So this is actually a strategic decision which has a trickle-down effect from the start until the end of the proceeding. And again, if you get the right arbitrators, it can become quite cost-effective because there's need not be much explanation to the arbitrators, because they would understand what is happening. I did mention there is this great move in India towards arbitral institutions. It is, the last count, I think, registered arbitration institutions with the government of India is about 20 plus. So I think these numbers will grow. And when the Arbitral Council of India is set up, I'm quite sure the accreditation will be clearer. And then they will have maybe a regional arrangement, a city arrangement. This networking will start to form. And most arbitral institutions are actually forming because it is actually a market movement. It's a market movement because people see that there is opportunity. People are looking for this kind of services. So, for example, the Chamber of Commerce, it's actually natural for a Chamber of Commerce to have a dispute resolution committee and even provide dispute resolution services, including arbitration. It could be mediation and other things for its members first, eventually spreading out to the community. And if it's wide enough, you will find that it can even be cross-border. The best example of arbitral institutions coming out from commercial chambers is the ICC, the International Chamber of Commerce. It was set up in 1923 as a business council, user council, and then they suddenly realized that we should have this dispute resolution services, and they are one of the most respected and popular dispute resolution arbitration institutions in the world. So again, here parties have to decide in their contract, and in many standard form contracts, people try to get their institution in. So they become the appointing authority. In fact, in Malaysia, for example, the Architects Institute issues the standard form building contract, and the appointing authority in that contract is the president of the Institute of Architects. So it applies to various institutions. They normally will try to put themselves, get their institution to be named in the contracts as people are signing contracts, and hoping that when a dispute does come, they are the ones who are approached to actually constitute the tribunal and administer the arbitrations. So institutional rules are coming out. It is quite common now. Everybody's starting to come up with their own institutional rules. And all these institutional rules have what I call a strong backbone, which is common. They will have the procedure. It will be chronological in nature. If you study the rules, it will start from appointing, conducting the arbitration, just like the Arbitration Act, until it comes to the award writing, and then how the award is delivered. And what the thing is, one thing that is happening among institutions, it has become what is we say a cutthroat business. It is become very competitive. When you have competition, people try to innovate. You can see what things have come out. They have come up with innovative procedural features. For example, emergency arbitrators. I mean, emergency arbitrators, if you 10 years ago, it was an unheard of thing. When I started in 1990 as an arbitrator, there was no such thing as an emergency arbitrator. What's an emergency arbitrator? Emergency arbitrator actually displaces the court for before the arbitral tribunal is constituted, you have if you need some interim relief, then you can go to the emergency arbitrator. And many countries have done two things. So one is that they have many institutions have come up with the rules, and the lex arbitri, the arbitral legislation recognizes there's such a thing called emergency arbitrator, and the award of the emergency arbitrator will be enforced. We have now expedited procedures. People are saying that it's taking too long. We want to have a fast track arrangement. There is, in fact, I remember there is even summary procedures, no case to answer, kind of thing. So summary procedures. I remember it was when I was in the 90s, late 90s. In fact, late 90s. One was put before me for a summary dismissal of the claim. In fact, I said no, I can't do that, because you know what, they quoted the Mila Costas as the authority for that. But now we have rules that provide for such things. So parties have agreed to these rules, and they are bound by these rules. Of course, now we have consolidation. One of the disadvantages of arbitrations is unless parties agree or even join the proceedings, you cannot actually bring similar subject matters, same parties, and put them together and say that I want to hear these things together because they're all related. You don't have what joinder procedures. For example, in one of the great advantages under court procedure is you can have a third party being brought in and joined into it, because that person will be the one. Is, for example, somebody is actually mounting a claim against you. You will say, I am not responsible. This is my defense. But if in court, I'm talking about, but if there's anybody who's responsible, it is this person. I bring this person in as a third party. But this usually can't happen in arbitration. But now with joinder procedures coming in, related contracts, multiple contracts can be actually brought in to deal with it. So the flexibility is there. And then we all understand, once you are in the system, once you understand the institutional rules, what you look for is actually the differences. And that's how you deal with it, because you will have a certain expectation what the rules are. Then neutrality, there is a requirement for the arbitration to be a neutral forum, and it is done again. Oh my goodness, I've got only 15 minutes left. I have to go quite fast. Then neutrality, it's basically there's disclosure requirements. there. Representation, you can choose your representation. There is no problem of choosing. And arbitration is normally most safe seats allow people to come in to represent there. Finality, I've spoken about it. We'll move on. And then universal enforceability, I've spoken about it. Then control over the procedure also. And then, okay, let me talk about this. Displacing home jurisdiction. When you have a dispute, what do? You will always go back and try to resolve your dispute as where you are. You don't want to go to somewhere else. Let's say if your dispute, the subject matter is in India, you want to resolve your dispute in India. But if you want to resolve your dispute in India, you must be able to persuade the party who is signing the contract with you to agree to have the dispute resolved in India. Let's say if you don't have an arbitration agreement, perhaps then it will be resolved in India. But let's say if you have an arbitration agreement, one of the bargaining that will go on, one of the discussion that will go on will be always trying to say, we want a neutral forum. Let's go to Singapore. Let's go to Malaysia. Let's go to London. Let's go to Paris. So they will say, but the problem is, again, it is expensive. And sometimes you don't know. So forum shopping, that is why everybody is actually now marketing. I'm a safe seat. I am selling London is the best place to be to arbitrate. Our courts are very supportive of arbitration. We have the best institutions. For example, Singapore is doing that. Hong Kong is doing that. So then parties can decide, and what is called forum shopping is becoming something very, very common. And then the real concern that a lot of people have, of course, when they are signing the contracts, they may be very happy to sign it at that time. But the people who are more experienced, they will actually have they will analyze to see first, are the courts independent and impartial? Is there political instability? What about funding arrangements? Is the third-party funding allowed? Litigation funding? Are there unknown matters that you have? So all these things will be concerned. So what will be the best forum is what Gary Bond described, the least unfavorable forum that a party can obtain at arm's length negotiation. It is not the best, it is the least favorable. So I think the mindset has to change. And when the negotiation is going on, the attitude is to get the least unfavorable forum that I can get to settle my dispute. And therefore the deal can close, the business contract can close. One of the best things that happened in India, I believe, was actually the 1996 Act. The 1996 Act came in quite early, and then it was done. And then after that, there was this 2015 Act, which put in the amendment because they wanted to put time frames in. Then the 2019 Act came out with structures. And now there is a, in the old days, before the 2019, I think 2019 Act, if I'm not mistaken, if you actually filed setting aside in the Indian court, there will be automatic stay of the arbitral award enforcement. So so you have to go through the entire process until the Supreme Court before you can get that award to be enforced. So that takes a long, long time. So the latest amendment has actually settled this. I think 2019 it settled it. But there is one new provision that has now come in under 36(3) that basically where the if there is actually before that, if there is an element of fraud and other things, the court will still stay the proceedings. It will be stayed. The other thing is foreign arbitrators. There was when the amendments were done, in 2015 and especially 2019, there was a concern about foreign arbitrators will have to be in accordance to Schedule 8 of the Act. Now, Schedule 8 has been removed and they have put in regulations. So what it would mean, basically, regulations will give the flexibility of to the various institutions, and particularly the Arbitration Council of India, to decide on the qualification requirements, and there may be some flexibility there. So, one thing is that if you want to be an arbitration hub, then you have to open up. You have to open up, you have to allow people to come in. You cannot say that I want to be a hub, but only on my terms. It doesn't work. It doesn't work, because I think you have to allow. Hub means the foreign people who want to, parties that want to arbitrate in India must be allowed to bring in their expertise. They must be allowed to also choose their representative. They must be allowed to actually decide on the procedures. They must be, and this has to be consensual with the Indian parties. In fact, I think the most successful arbitral institutions follow the London safe seat principles, which basically provide for a number of things. You must have a legislative framework that is friendly, that is there already. You must have a good bar. India has a very good bar, good lawyers. You must have facilities. India is creating facilities. We must have, accessibility. And I think there's enough accessibility in India. Many flights are going out. Then you will have immunity provisions. And then the courts are actually arbitration friendly. So all that is there now. And so I'm very confident that it will go on. So basically, business is going to become, if you're going to become the third largest economy of the world, it can happen with dispute resolution. Even China at the beginning closing up now has no choice but to open up and allow dispute resolution to come in. So they have actually said that, okay, we will allow people, but they don't have many. I noticed, China does not have many international arbitration. But the interesting statistics that if you go to every safe seat or arbitral centers like ICC, LCIA, SIAC, or even Hong Kong, a large number of the parties who are arbitrating are actually Indian parties. So that suggests Indian disputes are actually going out. So if you want to get back the Indian disputes and make arbitration relevant in India, especially where foreign parties are involved, there is a foreign component, then you will have to actually mirror, or you will have to adapt to follow these other safe seats. But domestically, I always say that you must also create that kind of domestic structure that will bring out your international arbitrators, that will bring out your expertise to become international arbitrators. Normally you have to come through a domestic arrangement, and the domestic arrangements must be as equally efficient as international. In fact, in many countries, there is only one act, one regime for both domestic and international. The same standards apply. In fact, I think that's the ideal situation, that what applies domestically also applies internationally. Those are the countries that are actually well structured and they are confident. But of course, many countries also feel that domestic arbitration should have more control. There must be more supervision. There must be by the courts. And therefore, they have a part A and part B, or part 1 and part 2. So I think emergency arbitration is now coming in. It is there already. So I'm not going to talk about it. I'm just told that 5 more minutes, so I'm going to allow for questions and answers. So the slides can be shared. The other thing is that COVID-19 is a very interesting thing that has happened. It has equalized everybody. There is no more fun going that you are going to go to Paris and have your arbitration there, and also have a look-see around in Paris because you're having your arbitration there, and it's neutral and all these things. Because now venue is no more. Of course, arbitration, the seat concept is that the seat can be anywhere. But because of COVID particularly, hearings can be held anywhere, because it is many of these hearings are now virtual. In fact, I think that the real skill set of an arbitrator, other than for domestic arbitrations, once the COVID matter settles, is to have a good platform or protocol for virtual hearings, and that will be very, very important. So I think you have to actually look at that. I think I'll stop here. Imba, you're there. You want to take over? Because I see so many questions here.
Thank you. Thank you.
Sorry, I hope I've been, I'm been told that 5 minutes, 15 minutes.
No. Just as a cautious, it is always, there was one question stating that in arbitration, the time is given, but still there is the parties as well as arbitrators are not adhering to the time. That shouldn't happen for our presentation also. That's the reason why it was informed. Thank you, Datuk. Swetan?
So to all the attendees present, you can post any question you have to Professor Sundaraju in the Q&A box. So right now we have 3 questions with us for now. Sir, if I may read it orally to you and you can answer on live on the air, sir. So
yes,
sir.
okay. There is this Arbitration Council of India. It has not been set up. We are all waiting to see, because the high-level Sri Krishna high-level committee actually recommended the setting up of that. It is very interesting because it is supposed to be a regulatory body. In most jurisdictions, arbitration is unregulated. So this is something new. We have not seen anything like this, where there is going to be a formal regulatory body. All arbitrators must be registered, we assume. That we don't know how it's going to work. They are also going to be, there is also a provision for a depository of all arbitral awards. So all this not been implemented. So we are waiting to see the actual structure that comes out. But the law is in place. The provision to create these structures are all in place already. So if you ask me when, I don't know. I'm waiting. So in fact, when writing the book, I've actually left it to be updated before. We won't know. I think it could happen now or could happen anytime. But the latest amendment where they amended to regulations is for the Arbitration Council of India. So to allow more flexibility to them, I believe. The next question. Okay. Can a party unilaterally appoint an expert arbitrator as ad hoc arbitrator without approaching the court, or jointly with the approval of the other opposite party? Let me explain how arbitration agreements work. Arbitration agreements is basically you have an agreement for an arbitral tribunal to be appointed to hear disputes in the event it arises between the parties or in connection with the contract or what it is. So it depends on the width of the word, but normally the first opportunity is for both parties to agree on a designated arbitrator. And if the party cannot agree, the parties cannot agree, one party cannot unilaterally appoint the arbitrator for a sole panel. Okay, that means that, let's say that it's a sole arbitrator. So what will happen in that situation is that if parties cannot agree, there will be an arrangement maybe in the contract to say we designate the Southern Indian Chamber of Commerce and Industry president to appoint the arbitrator. So that power is given by the parties agreeing to the president, and the president will then be empowered to appoint, and the appointment will be binding on the parties. Now we move on to the next situation. What if the contract is silent? There is no appointing authority. Then I think under the Arbitration and Conciliation Act 1996, it goes back to the Chief Justice, and the Chief Justice delegates to the various high courts, I believe, in the various places. So basically, there is no lacuna. There will never be a situation where an arbitral tribunal cannot be constituted in India. It will always be constituted. It depends on the procedure itself. And then, of course, it cannot be done unilaterally. Okay, I think I hope I've answered that. Next question, we have stated, okay, curate their own arbitral institutional rules designed to attract cases. Designed to attract cases. Okay, let's say if you are a new jurisdiction, I mean, let's choose that you are a country in Asia or in Africa, and you have an institution there. You will actually, and you have set up your institution and you want to attract arbitrations come in, you decided to do your set of rules. You will normally do a set of rules that are universally acceptable. That will be the first basis. So you will either take the ancestral arbitration rules, which everybody uses for arbitration, and you will modify it like what the KLRCA or AIAC used to do, or other institutions used to do. Or you may write your own set of rules having those main components in, and then you will try to put in some interesting points, but it cannot be odd. For example, you may even put time frames in, but the time frames cannot be too tight. There must be a certain amount of flexibility. So how do you, I said arbitral institutions often curate to their institutional rules designed to attract cases. For example, they may put in emergency arbitrator. They say, okay, we can give you interim relief before the arbitral tribunal is constituted. They may have, let's say, for example, an expedited procedure for a certain amount. They say if the disputed amount falls within a certain amount, then the procedure changes to a faster procedure. That is like, for example, in Singapore, the chairman will decide. The chairman of SIAC will decide. So those kind of things are designed to attract and to make the process attractive to parties. Which is the, I'm trying to understand the question. Okay, for instance, going to court even for appointment is going to, no, one thing I must tell you all, I've been writing the book. I've been going through the Supreme Court judges, Supreme Court's decisions, and they are very enlightened. I must say that they are moving in the right direction. They see the law quite clearly. In fact, I think the way they are handling it is in fact in tandem with the idea of making arbitration an important element of Indian commercial reality. So, together with the courts. So it is actually the Indian courts have become quite friendly, and I think they are playing their role. And the legislation is, some people say that India is taking one step forward and 2 steps backwards. I disagree. I say that actually the trajectory has changed. It is taking 2 steps backwards, but 5 steps forwards. So you can see, but this is a tension in a large country, because you have all kinds of cases. When we want an authority in the world, we will go to India and we will find an authority for any situation, because it's so diverse and people are prepared to go to court, and the courts are prepared to actually deal with it. Whereas in arbitration, one of the issues in arbitration, because of the confidentiality, you will not get that kind of precedent creation unless the matter goes to court. So there's talk about, I think they want to actually have a depository of awards. They want to have redacted awards so that people can see what's the quality of the arbitrators. ICC is doing that. SIAC is doing that. They are all saying that, okay, they sanitize the award. You can see how the quality, because they have scrutiny. Some, for example, one of the, you want to attract arbitration, you provide scrutiny. That means you will check the award that it is enforceable to a certain level before you allow it to be published. To attract cases, you also have, let's say, strict timelines. But the timelines now in India is in the law itself for domestic arbitrations. And for international arbitrations, there's a bit more flexibility. But in, let's say, ICC arbitrations, even if you are 3-panel arbitrators, we have basically we have to give the award 3 months to the institution for scrutiny before after the process, what is that, is declared closed. I just lost that. Okay, yeah, we just lost the thing. Let me come this side. Oh, we got back. I got back. Sorry. Yeah. Again. Never mind. Never mind. Oh, camera is there. All right. Okay. Okay. I can't see the questions anymore. Sweden.
Yeah, yes.
Okay. Next.
We just have a couple of more.
I think institutional arbitration will help India. It will help India because I think there will be more structure, there will be more training, there will be more selection, there will be more scrutiny by the arbitral institutions. And then, of course, I think institutional arbitration, the way the India is planning it, y'all are planning it, is I think y'all are making it structural in nature. So I'm actually very confident that it's going to do some good rather than bad. So of course, a lot of people don't like structure, and then they don't want to be told that this is the way things should be done. And then, of course, no arbitrator will accept that he's given a timeline to finish his work. But if this is what the parties want, then if you accept the appointment, that's what it has to be. Can you share your experience whether proceedings under arbitration are speedy and cheaper than ADR? ADR, alternate dispute resolution, there are two types. I've always said that arbitration is what, and litigation is what is rights-based. Of course, the other types of arbitration that is going, other types of ADR that is going on is mediation, very popular. And in between, there's one thing called, in the construction industry, called statutory adjudication. Which is quite an interesting development. It is rights-based for payment only, but it's temporary binding until you go to arbitration or litigation. So this is to improve the cash flow. So I believe there are 5 countries around the world. In Malaysia, it has become very popular. In fact, it's more popular than arbitration because everything has to be finished in 100 days. So 100 days, you file your claim, but it's only related to payment in a construction dispute. And then after which, they'll go through a very quick process. Normally, there is no hearing, documents only. If there is a hearing, it's a limited hearing, only to 1 day. Everything is on documents, and the person actually decides and comes out with a decision. That decision is temporarily binding unless it is set aside. And then if you want to challenge it, if you don't set it aside, you don't succeed, then even setting aside, it is only very limited. It has to do with jurisdiction, fraud, and I think basically that fraud or the person has exceeded the time limit, because the person won't get paid, and the adjudication decision is void if it's not delivered within the time frame that is set out in the Act. So what happens is that the cash flow is enabled. So parties will have, once they receive the decision, it may be rough and dirty, but but you have that decision, you get paid first, and then after that, you can actually challenge it while the other party will challenge it in arbitration or in court. But the advantage of this is this temporary finality. If it is actually a reasonably good decision, commercial parties normally accept it and they move on. So cash flow in the construction industry in most of these 5 jurisdictions, Singapore, Malaysia, Australia, New Zealand, and UK. I think, of course, UK, it includes Ireland. They are having that. So, I mean, Ireland is a separate country, but I believe they also. Now, Hong Kong is looking at it. So this is one of the things that are going to change. Somebody wants to know the scope of advocates as arbitrators. Of course, when I started, the dominant professions were the engineers and the architects and the quantity surveyors who sat as arbitrators, because construction industry was the main, it is still that produces the most number of arbitration, a lot of disputes. But I think later, because the people who presented their cases and all these things were lawyers. So once lawyers come in, advocates come in, they actually learn the business. And once you learn the business, you understand that because you're arguing the concept, then you will actually want to sit as, you say, I can solve the problem better. And that's where we have now situations like expert evidence. Expert evidence is coming in. You will see very common, when I first started arbitrating, we were considered the experts, and the people will argue the cases. They will never bring in expert witnesses. Now delay analysis is very, very common. Quantum quantification is also very common. So all these experts are now coming in, and even sometimes even liability, they're trying to even tell you how the liability should be apportioned through expert reports, through experts. So practice has changed. Practice has changed. So we all have to adapt to it. This is and things are becoming more complicated. I remember when I first started, an award was about 20 pages. Now an award is about 100 pages, 150 pages. I've written awards about 500 pages. So it's a different. 20 pages. People will expect that. And in the old days, under I think the earlier act before the 1940 act that you all had in India, which was we had our own version in the 1952 act. Reasons were not required, but parties were asked for reasons when they come. They said, please give reasons. The default situation, reasons were not required. But now in any modern arbitration legislation, reasons will be required. So one of the main job of the arbitrator for transparency and good form, he has to explain how he came to a decision. He has to actually set out the contentions of the parties. He has to analyze them, or she has to analyze them. And then after which, come to the decision. But as you're coming to the decision, set out your reasons for coming to that decision. So that makes it also a situation where people will say that, look, this can be challenged. But I think, again, most of the arbitration legislation have moved away looking into the merits. They say if you come to Caesar, to Caesar, you chose the arbitrator, then you leave with his justice, but subject to safeguards. The procedural due process, the arbitrator must follow the law, in getting the things right, must set out the reasons, and must give the opportunity for the parties to hear, and then it must be properly constituted. So if you look at the setting aside provisions under 34, I think under in the Arbitration Act in India, it is the same as the unsettled provision. It is about jurisdiction, proper constitution, not going out of the jurisdiction, and then the natural justice, the parties must be heard, and public policy. Public policy is one of the things. Public policy, I think, has been now reigning in India. So it's becoming clearer because it's been defined in the subsequent acts. Right. Anything else? I think I overstayed my welcome, is it?
No, not
Any
at
other?
all. Thank you so much, and thank you so much for patiently answering.
Welcome, welcome. It's a pleasure. It's a pleasure. Yeah, in fact, I would rather be in India, in Chennai. I remember doing one talk. It's more fun to actually see the people, or talk to you all. But by you say, with a virtual platform like this, you can reach the whole world. So you may have people from all over the world watching this. But I think thank you for the opportunity. I hope I've been clear, but I had to rush through the slides. The slides can be shared if we already shared. There's a paper also. It need to be shared. We have done a paper that can be shared. In fact, maybe better the paper will explain better than the slides. And then, of course, I want to advertise my forthcoming book in India. It is, it's very interesting to write a book on law, practice, and procedure in India, arbitration, because I learned a lot of it, but I used a group of very talented young people, starting off with first, what I will say, a junior editorial team, and then having a subsequently senior editorial team. The senior meaning they are not more than 30 years old. So this book is by young people. I think I'm the oldest, maybe twice their age, or any of them. But it is going to be, it's about 1,500 pages. They will say a typical Indian book, so very thick, but we are hoping to cover all the things. Many of the things I spoke about is all there discussed in the book in great detail, and I think, of course, in a better form, I suppose, and maybe with greater what I would say in greater prudence, and I tend to say things more than when I write it down. All right, then. Anything else? Can I help you out?
Thank you so much, sir. Now I hand over the floor to Mr. V. Inverjin again for a vote of thanks.
Thank you, Swetan. Thank you, Datuk Professor Sundar Raju. It was really enlightening session, entire 45 to 50 minutes covering the entire arbitration landscape in India. As the chairman of Arbitration Committee of Southern India Chamber of Commerce Industry, we are really thankful for you to share about the growth of institutional arbitration, and more interestingly, highlighting the Arbitration Council of India, which is likely to be established, and it's going to be the future of arbitration in our country. And this is a wonderful opportunity for us from SICI to host you and hear an elaborate presentation about this development and the scenario of arbitration in our country. At this point, I like to thank the secretary. I think Mr. Vinod Solomon also is here, the secretary of the Southern India Chamber of Commerce Industry, for giving this opportunity to invite you and make you share whatever knowledge or whatever what you can say as a teaser of your book, what you're going to bring out about arbitration in India. This will be a really good takeaway for our members, the SICI members, the legal fraternity, the law students, as well as diversified professionals. And with these few words, I thank all of you, one and all, the participants. Without the participants, any event doesn't reach its objective. Here, we are very happy that more than 100 participants have accepted to join. Not only that, the questions, the way the questions were put forward were really interesting, that people are really serious to take about arbitration, more interestingly, institutional arbitration. Thank you, one and all. And we can all meet in a next occasion wherein this platform of webinar series would continue, particularly with the SICI support. Thank you, friends, ladies and
Thank you so
gentlemen.
much. Thank you so much. Goodbye.
Goodbye.
See you all again.
Thank you.
Thank you, Professor. Thank you, sir. And huge thanks to AIADR for its support and KFCRI. Thank you. See you all in the next webinar.